Welcome, everybody. This is Planet Green Trees, episode 187. Someone edited it up the other day. It was like 4 years of weeks.
Lots of weeks.
We're calling it Guns, Medical Cannabis, and SB 783. Today's February 20th, 2014. Calling numbers 1-347-326-9626. Visit us at www.planetgreentrees.com, 347-326-9626. And, of course, Planet Green Trees is Michigan's medical cannabis and cannabis reform blog talk radio show. We are 2 hours of jam-packed information and up-to-date news and information for the community.
Merriment.
I'm your host, Michael Komorn, and Komorn Law. Besides me, Chad from Komorn Law and Birmingham Compassion Club. Welcome, Chad.
Good evening. It's nice to be here.
Contributors not yet arrived, but I know and believe on their way.
Or stuck in a pothole.
Is that the story?
Oh, my gosh. It's incredible out there. Rain, potholes.
Terrible.
What is going on?
You have to get on the spaceship, avoid those things.
Car-eating potholes.
And these contributions will be taking place at some point, I believe, tonight. Rick Thompson from the Compassion Chronicles, and he'll be bringing you the news and his comments and thoughts on some of the topics we're going to be talking about. Additionally, Jamie Lowell, the producer of Planet Green Trees and director at Third Coast Compassion, and person responsible week after week for providing the outstanding lineups that we have. And his responsibilities for tonight would have been the following: bringing to the table again the discussion of Senate Bill 783, a bill that would change the Michigan Medical Marijuana Act, allow landlords to prohibit medical marijuana activity on private property. This was introduced by Senator Jones and was subsequently heard in the Senate Judiciary Committee, chaired by Jones, and passed out of committee unanimously in an inordinate amount of time. Also talking about tonight, the student government at Central Michigan University passed a marijuana reform measure through the student government House and Senate, where now awaits consideration from the student body president. Also, we are going to be revisiting the issue of owning and possessing firearms while being a Michigan Medical Marijuana Program participant. Joining us to expound on these topics is a woman I like to call the hardest working woman in Lansing, Robin Schneider, the legislative liaison for the National Patients' Rights Association. She attended and has been present at many of the functions taking place at the legislative level in Lansing, but most recently at the Senate Judiciary hearing on Bill 783 and offered testimony. Robin also has had discussions with groups in support of the measure. Additionally, calling in will be Josey Scoggin, founder and president of Sons and Daughters United, executive director of the Capital Area Compassion, also attended the hearing and offered testimony. Ian Elliott, as we mentioned before, from the Student Advocates for Medical and Recreational Cannabis, a group formed as a registered student organization in the fall of 2013 at Central Michigan University, will be calling in as well. Ian and his organization provided the major influence for marijuana policy change by the student government at Central Michigan University.
Genius. Should catch on like wildfire.
I think so. I think they're still waiting on a vote to make it official, but what a great way to get it started. And of course, to really change the way people think about it, that's the environment to do it.
Immediate real relief as well on campuses.
We're going to also try to discuss a little bit on the legal environment involving guns and marijuana activity protected by the Michigan Medical Marijuana Act. I'm going to rant in a little while. I want to give a couple shout-outs. Again, we were back in court on the people of the state of Michigan versus John Roberts. We recapped the testimony of the Section 8 hearing today and heard from a cancer patient who has actually been using Rick Simpson oil. And prior to beginning to, I say Rick Simpson oil, but it's honey oil or cannabis oil. And prior to his actual using cannabis, he had been recommended to have radiation therapy. And after 4 years of cannabis oil treatment, he no longer needs radiation therapy. He was able to avoid that as a process, and now is taking a daily dose. I don't know if there's any more compelling patient testimonials than that. Of course, we have other challenges in the case, which are all due to the terrible Court of Appeals cases. But I want to say, again, thank you to all the patients that participated. They drove from all over. There's another patient who drove all the way, I think, from Grand Rapids, who insisted on testifying and telling his tale and his support for the defendant and all the good things that he's doing for the community. And really, it's an amazing story. If this case does not get dismissed or we don't get to a jury, there's a major problem with the way things are going in this state. Not that we don't already know that, but this case exemplifies the individuals to whom this act was speaking about and the voters intended to be having relief. So I want to thank all those really heroic and inspiring patients. And I say this if they're listening or the people that know about the case, that I had to not coach them, but I had to tell them to be sad about their condition, that these are people that, despite the fact that they've been told that they're not going to survive and to get a will and contact their loved ones, they don't live like that. They live every day and as if it's the last and the most important. It's inspiration to see the way that they are dealing with their challenges. Also, big thanks to a good friend, compatriot Dewey, who has been assisting me and was all week, and appreciate you being there, my friend, and getting me there to places on time.
Professionally.
And, of course, to his better half, better three-quarters, Pam, who is responsible for all of Dewey's good deeds, I think. Just kidding. The Michigan Medical Marijuana Association, Michigan Medical Marijuana.org. I want to thank all the moderators and administrators who volunteer their time to create a safe and comfortable environment for the patients to evolve the conversation about medical cannabis. Also, the Marijuana Ranch. Call 313-422-5281 for your tour of the Cannabis Cultural Center. Our good friend, Dr. Kumar Singh at the Green Light Clinic, 248-390-0574. If I had any hesitations as to why the case that I spoke of with these sick patients, why their case would be challenged at all, would be because of the fact that the doctors that were involved here didn't have a gold standard certification process. Unfortunately, these were the oncologists for these cancer patients, and they could care less about what the levels are of THC in the blood of their cancer patient, and they would think it's ridiculous that they'd be required to do that. But the two recent cases have put a scrutiny that's unrealistic on the doctors, and I can't say that I'm warning, and I warn every week, that patients need to be more responsible and accountable for their chart. You got to contemplate that the doctor that's called to justify the certifications to be asked about the bona fide relationship and if they can attest to actual medical efficacy or why the patient should continue to use that. And if the doctor can't say or give a reason, you're going to have a problem. So think about that, and think about Dr. Kumar Singh at the Green Light Clinic and the other physicians that have stepped up to the plate and are willing to come to court, as Dr. Singh is, Dr. Bob Townsend, Dr.
Kumar Singh,
Crocker, David Crocker. And there's many others. And of course, Paul Meyer, Dr. Paul Meyer was fantastic in his testimony in this particular case. I want to give a big shout out, and I know the community is supporting our dear friend Bob Redden and Tori Clark. Tori, of course, has recently become ill and is in hospice, and Bob is taking care of her. And I want to give a shout out to our good friend Eric Gunnels, of course, the trustee for Thetford Township and chairman of the steering committee for the Cannabis Stakeholders Group, and really someone who's been an outstanding advocate for the community and representing patients' rights. And I want to give a big shout out to Eric. All right, so what are we going to talk about? There's always so much to talk about. In light of the gun discussion, I wanted to bring some of that stuff up. I know it's a topic that's been going on for a very long time. I get calls all the time in terms of the can they take my CCW away? I have a permit. I've had one forever. What should I do about my guns if I'm growing marijuana? And as a lawyer, I always advise from the position of safety. Unfortunately, the Michigan Medical Marijuana Act, as it's been interpreted, is started from the premise that marijuana is illegal in Michigan. The Michigan Medical Marijuana Act did not legalize marijuana. When you hear someone say, I'm legal, I don't know if that's the accurate way to describe it. Instead, a better way to interpret it, according to the Michigan Supreme Court, and an interpretation that I disagree with, is that marijuana is still illegal. All kinds of marijuana use is prohibited. Any kind of it is prohibited by the Public Health Code. And in limited instances, if you're in unambiguous and strict compliance with Section 4 of the Michigan Medical Marijuana Act, you are entitled to an exemption from what would normally be considered illegal behavior under the Public Health Code. And of course, the exemptions that come along with it are intended to protect against criminal prosecution, criminal arrest, forfeiture, any issues regarding your custody of your children or visitation, and any other licensing or privilege that an individual would have in the state of Michigan merely because they are, in fact, a medical marijuana patient. In other words, your choice of medicine should not make you a lesser citizen, and the other constitutional rights or administrative rights that a person would be entitled to have should not be compromised merely because of the status of a patient. Now, as the stories go, someone has an interaction with law enforcement in some way. Let's start with the worst case scenario and why people have to be on the safe side. First of all, because marijuana is illegal, and it's illegal federally, despite utterances that the federal government isn't interested in prosecuting patients or caregivers, there are people that are in prison, and federal prison, for the act of possessing a firearm and growing marijuana, and the punishments at the federal level are severe beyond belief when you start throwing guns in. So understanding that to be the case, and the size and manner in which the caregiver would be growing, potentially outside or inside, that is the number one risk. The second risk is that even if you are prosecuted under state law, I should say that the federal mandatory minimum on guns associated with felony behavior is 5 years mandatory to run consecutive to whatever your sentence is on the underlying felony charge. In state court, there's a similar type of charge. It's called felony firearm. That means that if convicted of a gun charge, a firearm, where it is used in the underlying felony behavior. Now, the law requires that there be some underlying felony behavior, and what happens in these cases, and it's used as a method of leverage to really take what would be a lesser liability case, a person charged with some violation of the Public Health Code, and it throws into it this gun charge, which also, like the federal law, has a mandatory prison sentence, mandatory 2 years in prison if you're convicted of felony firearm. You don't get paroled. It's a flat 2, and it runs consecutive to whatever other sentence you may have. So an individual could theoretically get convicted at trial of felony firearm and manufacturing marijuana, which is a 4-year felony. They could get probation on that if they have no prior record. But before they serve their probation, they would have to go serve 2 years in the state prison system. Also, what is terrible about this state crime is that it is, in the jury instructions that are read to the jury, very confusing. And the way that I just described the law is the law, and it doesn't play out that way in the jury instructions. So when the jury seems confused, or the jury's looking for direction, and there's arguments of how it should be, how the jury instructions should be interpreted, and the lawyers are arguing about that in their closing argument, the judge is the one that really determines how the jury is supposed to interpret the law, and they then apply the facts to the law as the judge has given it to them. And the jury instruction is not clear, and it creates a lot of confusion. And what I'm trying to say is this, that the law requires there to be an underlying felony. That means, let's use an example. The stop in, let's say they execute a search warrant at someone's house for whatever reason, whether it's valid or not, let's not get into that, but they're inside, they find some kind of technical violation, and in the room next door to the grow downstairs in the basement is a pistol in a box on a table, because whatever, it's a pistol owner, or let's say they got a shotgun that's in the closet in the basement. This possession of this firearm in the commission of the alleged manufacturing marijuana illegally, and of course I'm assuming that they found some kind of technical violation, which takes you out of the immunity provisions of Section 4, and the behavior of manufacturing marijuana or growing cannabis is now in the Public Health Code prohibitions, and you are alleged to have committed a violation of the Public Health Code, felony behavior, the manufacturing of marijuana illegally, and because there was a firearm that was being used in some capacity, alleged, with the manufacturing of marijuana, the charge, it would be, 4-year, 7-year, 15-year felony for the manufacturing of marijuana, depending on the plant count, and a 2-year felony firearm. Now, I just described to you how and what has to take place factually in order for a charge like that to take place. In fact, just to understand a little bit more from a defending position, the firearm needs to be possessed in the commission of the underlying felony. So sometimes situations come up where someone's not home and the police raid the house and they find the grow in, or even if it's not a medical, but let's assume that it is. Let's say the police find that it's not in compliance, or they don't know because nobody's there, and they take it all down and they find a gun in close proximity or a gun in the house at all. The concept here, and people get charged with this all the time, is that how can you possess a firearm when you're not at home? That's at home. Meaning the crime demands that the firearm be possessed in the commission of the felony. Now, there's different types of possession. An individual can actually possess something. I'm possessing this microphone that I'm speaking into and the pen that I'm writing with. Also, at home in my closet, I own shoes that aren't on my feet. I possess those as well. That's called constructive possession. They're mine. If my wife walked into the closet, we would know they aren't hers. They're mine. I live there at that house, and they're mine. That is constructive possession when I'm not there. And the argument would be that if individuals constructively possessing the firearm, while they are constructively possessing the plants that they are growing illegally. Now, it seems ridiculous when, in fact, I think the law's intent was to prevent an individual from selling drugs out on the street with a pistol in their waistband. That is the more classic felony firearm associated with controlled substance violations. And unfortunately, as it goes, sometimes it becomes a tool of prosecutors, and it's extended to this very, very wide range of factors. And there are legal issues regarding the nexus and the accessibility of the possession and the close proximity. These are all legal issues or even factual issues that you would argue to the jury. But the point is that with this charge, in conjunction with a manufacturing or possession of with intent to delivery of marijuana, whatever the traditional charges are, it puts extreme liability on an individual because of this mandatory 2. I would tell you that, in any case that's a medical marijuana case, I believe, if you're able to argue medical marijuana regardless of the facts, I think that you've got a good chance of winning. Why? Because I think the general overview of the community at large, obviously from the 2008 election, and as things evolve nationwide and new polls are taken, it's 70, 80% in some jurisdictions. There's an overwhelming support for medical cannabis. Taking any medical cannabis or marijuana case in front of a jury, I think, you've got better odds than most cases. The problem is that nothing's 100%, and with the gun charge, there's always the fear of the defense attorney for their client that the jury doesn't understand the implications of it. The jury is never told that what the defendant's sentence would be. They're not to consider that. They're instructed not to consider it. So in some instances, they say, the gun's not a big deal. The marijuana seems like it's a big deal. We're going to show them and show those police they should be not, taking down this place. But the guns, who cares what's a big deal? It seems like it's not a big deal. So we'll find them not guilty of the marijuana and find them guilty of the gun. Now, this is an inconsistent, illegal verdict. I mean, if people were listening, there's got to be an underlying felony. There's got to be a guilty manufacture of marijuana in conjunction with the felony firearm. However, juries are allowed to render inconsistent verdicts. What does that mean? That means that a verdict has happened that is legally inconsistent, and you have nothing to say about it. You're going to be fighting your appeal while you sit in prison in the Michigan State Penitentiary.
This happened recently. Not the prison part. the inconsistent verdict part.
Right. Well, that happens. It happens sometimes. It happens in because that's the system. And as good as it is, as bad as it is, the confusion associated with this and the factors that I just described are reasons at times why the actual why this type of charge is used by prosecutors to effectuate leverage as you get ready to go to trial. In other words, you've got, as a lawyer, I'm going to sit down and have an additional conversation about the outcome, just so my client is clear that their principle of why they want to go forward, independent of whatever their beliefs are, and independent of how right they may be, that there's a risk involved and they have to be aware of it. So that's how the gun issue comes up, and that's why it's so important that my advice is understood as being advice to err on the side of safety. What can one do to protect themselves against this? Although it kind of takes the reasons away why an individual would possess a weapon in their home, I would suggest that you take the firearm and move it as far away from any alleged, any marijuana, cannabis, contraband, etc. Obviously, the advice that goes along with this is make sure if you're growing marijuana that you're in strict compliance with Section 4. Your plant count is adjusted to the number of cards you have. And I even say back it off a little bit. Why even get too close to the line? The clone issue, the dead plant issues, consider those all plants. Assume that the police will consider those plants and look to call those things plants so they can take your nice rifle out of the closet and charge you with a felony firearm. Beyond the compliance with Section 4 is unambiguous, if possible, as it can be. The weapon should be as far away from the marijuana as possible. If you can have it unloaded, that's even better. If you're just not planning on using it, you're going to take it out and shoot it at a shooting range or hunt with it, and it's not really there for safety, you would consider not keeping it loaded or keeping the ammunition someplace else. This may sound ridiculous. Mike, why would I have a gun and not keep it loaded in the house? Well, I'm talking from the position of safety and not the reason why you would have a gun. But as it relates to the Michigan Medical Marijuana Act, one final point I want to make, and we can talk a little bit more about this after the break because the producer's here now and he's giving me the watch count. The calls that are coming to my office, which are the most disturbing, are that law-abiding citizens who have obtained concealed permit licenses or CCW permits or carrying a concealed weapon permits, which require a certain extent of a background check and an actual determination of no prior record of any kind in order to obtain this. And with it comes certain rights, and there's certain rules that one has to stay within, like any other administrative licensing, in order to maintain that privilege or license to possess a weapon and conceal it and carry it. The calls that are coming to the office that are most disturbing are that law enforcement agents are learning of patients' status who have CCW permits. And even though the agency that manages the guns in every county, which is a state administrative agency that is legislated by the Michigan state government to allow for counties to set up a gun board and regulate the activity there, the registration, the issuance of permits, the everything related to the regulations of a gun, that under no circumstances should they or would they know of who is on the Michigan Medical Marijuana Registry. And those two agencies should never cross paths. Furthermore, the individuals who would be providing that information to the gun board, I would argue, are violating the Michigan Medical Marijuana Act, specifically the misdemeanor for disseminating patient information. And the idea that a patient would lose their right to possess a license to carry concealed pistols for no reason other than being a medical marijuana patient is ridiculous. This issue has been fought in Oregon. It's been fought in Montana. There's a movie about it, I believe, in Montana called How the West Was Won or something like that. And I've addressed this at gun boards in the past, and I may be addressing one in another case that's coming up that we may want to talk about and reach out to our listeners to get the message out and the support out. But there would need to be a violation in order for the gun board to theoretically proceed with suspending or revoking an individual's permit, unless, of course, there's a law, unless, of course, the permit holder was a defendant. But still, I think that it's an irrelevant issue, and again, the dissemination from the arresting agency to the gun board would be a violation. Furthermore, and finally, the recent decision of Tierbeck versus Wyoming versus Tierbeck, to me, would end this debate finally, because the boards that are in charge of issuing the permits are state legislated administrative agencies that are only in existence because of the legislature creating them. They are beholden to the legislature that created them and nobody else. And what we know now is that the federal law and state law, according to Tierbeck, can run and coexist with one another. And any arguments by a gun board that it's ATF policy, which is what they've been using, because all medical marijuana patients, according to them, are drug addicts and people that should not be carrying pistols, so says the ATF, makes it in such a way that should not be a policy adopted by any state board, any administrative licensing board, and certainly not the gun board for the state of Michigan in any county. So for those reasons, we're going to wrap it up right there and revisit this, I guess.
We're going to talk about this toward the end of the show and more in depth.
But this is my rant, so I'm giving like the preview. I've got a lot of briefs up in front of me. I was going to read from, give some case sites, but
we're going to call it the now and later.
All right, that's fine. You can cut me off. All right, we're going to take a break, by the way, and come right back and get right into it. You're listening to Planet Green Trees, and call number is 1-347-326-9626, and we'll be right back.
Our evening began in Peter Sechel's comfortable study in his New York townhouse, where the candlelight was just right, the hi-fi was in the background, and the wine.